Good morning. I'm Ruthi Rajan, Deputy Editor of the Oath Legal Magazine. Thank you for joining the Oath GC Talk webinar series. As you know, today we're focusing on a hot topic, foreign direct investment in the UAE, in association with the law firm Charles Russell Speechlys and legal research partner LexisNexis. Our experts this morning are William Rakert and Mark Hill, who you can see on your screens right now. Before I introduce the speakers, I'll just give you a quick overview of our session this morning. The shift to the allowance of 100% ownership by foreign nationals of companies licensed and registered in the UAE is one of the most talked about and long-awaited laws to arrive in the country. The speakers will take a look at what the new rules are all about as per Cabinet Resolution number 16 of 2020, and how these changes will bring about a paradigm shift in the investment environment of the nation. A little bit about our speakers. Partner William Rakert is a dual qualified corporate lawyer with extensive experience advising on high-value deals in a variety of sectors. William has more than 20 years of experience advising on matters ranging from seed series investments for startups to complex multi-billion-dollar matters across numerous jurisdictions. His experience includes advising on M&A, joint ventures, private equity and venture capital transactions, restructurings, and compliance matters. Our next speaker is partner Mark Hill. With 30 years of experience as a high-level strategic commercial lawyer, Mark's areas of expertise are media, entertainment, IP, and technology. He has been based in Dubai since 1999 and acts for a variety of high-end retail franchising groups, leading local telecommunication firms, financial service sector clients, sports bodies, entertainment and media companies, celebrities and artists, production and events companies, as well as technology and app providers. Our expert speakers, William and Mark, will lead the session for the first half, and this will be followed by the Q&A session for the questions that we do receive. Over to you, William and Mark. Thank you.
Thank you, Ruthie, and thanks everyone for joining us today. So I'm Bill Reichert. I head up the corporate practice in the Middle East for Charles Russell Speechlys.
Good morning. I'm Mark Hill, and I head up the commercial TMT IP practice in the Middle East for Charles Russell Speechlys. Back to Bill.
So as Ruthie said, this is a hot topic, and we are going to try to cover some of the salient points of it. Next slide, please. Next slide again, please. So here's a little bit about what we're going to go over today. So we're going to talk about the main points of the law. We're going to talk about what it says about foreign investment, and I think more importantly, in some ways, what it doesn't say, because there are still a lot of gaps, a lot of questions. We've received already a very large number of questions from all of you, so we're going to make sure to make some time to go over as many of those as we can. We won't be able to get to them all because there really were quite a lot of them. And in doing so, we're going to try to provide some insights, hopefully some interesting tips and some things to think about. And then we'll sort of consider the next steps. You know, what we should expect, what's going to be possible, what's not going to be possible. Again, we don't know all the answers yet, but hopefully we'll have some of the answers for you. Next slide, please. So, just as a general introduction, the UAE, as we all know, is a very forward-thinking and business-friendly country, and I think they're always looking for new ways to attract investment, to be at the forefront of all sorts of business and commercial ideas around the world. And so we're always seeing new proposals, and I think this year has been even more well, interesting in that sense, and all the changes, both from a personal level, from issues related to allowing cohabitation, allowing for estates to be governed by the law of the nationality of where someone is from, all sorts of things. And then on the corporate side too, in terms of beneficial ownership, and I think this is really sort of the biggest change that anyone has seen, and it's caused a lot of stir. You know, we still don't know, you know, the full effect of this. but it is going to be a big change, and it's probably the beginning of a lot of changes. I think what it doesn't mean, at least not anytime in the immediate future, it doesn't mean local sponsorship is going to go away all of a sudden. We've had clients who've come to us and they say, oh, great, there's a new law. Can we go ahead and have 100% ownership? Well, not quite yet. And I think it also means a lot of the questions we got were about the free zones. Not all the free zones are going to disappear right away. So we're going to try to discuss a little bit related to all of this. Next slide, please. So what has happened? As we all know, previously, the Commercial Companies Law, and Article 10 in particular, had local ownership requirements or foreign ownership restriction. And so foreign ownership was limited to 49% for onshore companies. So the new law, the amendments to the law, amends Article 10, and it takes away that restriction. And so you no longer have the need to have a UAE national or UAE company own 51% of an onshore company. But there are limitations on that. Next slide, please. So in that regard, I think it would be helpful to step back a little bit and think about the previous changes to the FDI law. So as I'm sure you're all aware, in 2018, there was a new FDI law. And as you'll recall, it allowed for up to 100% foreign ownership for certain sectors in a positive list. And there were, I believe, 122 sectors or categories that were identified. But again, that didn't result in sudden sweeping changes to ownership across the Emirates. And that's partly because the details were very slow to appear. The law was introduced, and then it took a while to figure out. First, there was the negative list, and then we got the positive list. And even in both those cases, well, if you could apply for the positive list, it was all taken on a case-by-case basis. And so in that regard, you know, even though that law was really groundbreaking, it didn't change the landscape all that much. So these new amendments, well, now actually I should step back a second, because this new law, we're here talking about the foreign ownership requirements. The new law actually makes over 50 changes to the Commercial Companies Law. And those changes will all come into force on January 2nd of next year. The changes to the foreign ownership will come into force 6 months later, or 6 months from the enactment of this law. So it'll actually be March 30th, I believe, of next year. And then the FDI law, the previous one, will be repealed. Next slide, please. So in many ways, the amendments are similar to the FDI law, but it's sort of the opposite, and it goes a step further. So previously, you had the positive list, and if you wanted to invest in the positive list, you could make an application and get up to 100% ownership if the application was accepted. So now the way it works is there will be limited sectors for those of strategic importance. And there you still may have a requirement to have majority or even 100% local ownership. Everything else is in theory supposed to be open to 100% foreign ownership. Now, again, we'll have to see exactly how that all works out because we don't have the details of that. A similar thing is that up until now, you've always had to have a local agent if you had a branch of a foreign company, and that restriction will also fall away. So what that means is that the local ownership requirement should in theory become the exception and not the rule, okay? But again, we still don't know which sectors will be affected, and we don't know the details of the process to apply for ownership. Next slide, please. So as I mentioned just now, the changes to the foreign ownership will come into effect 6 months from publication in the official gazette, and that was on 30th September. So 30th of March of next year, that's when the foreign ownership restrictions are supposed to fall away. But our expectation is that in practice, it's going to take longer for that to happen because it will have to be implemented by an Emirate basis. So now what is supposed to happen? There will be a committee that will determine the sectors of strategic importance, but we still don't know, when that committee will be established. And so obviously we're not going to know the details. We're not going to know what is a restricted sector, strategic sector, and what is not. And so in that sense, we won't know where you'll be allowed to apply for up to 100% foreign ownership until that committee is set. And similarly, we don't know which sectors will be the strategic sectors. Similarly, the Department of Economic Development in each emirate will be able to determine the thresholds for foreign ownership. And so, as I said, there's still a lot of questions as to how this will be rolled out. So we have a general framework that in theory allows for up to 100% ownership if you're not in a strategic sector, but we still don't know the details. And I think that's part of the reason that we had so many questions from the audience. And really, we've all got questions and we're not sure how this is going to work. Next slide, please. So when trying to think about how this is going to play out in fact, I guess a question comes as to, will it be like the FDI law in the sense that the committee will take into certain considerations that were also set forth in the FDI law, and we expect that will probably be the case. And in particular, the restricted activities in the FDI law, as you'll see here, they included oil and gas, insurance, banking, defense, transportation, utilities, et cetera. These are all very important sectors for the UAE, whether that is from a defense and security perspective or just a commercial perspective. We expect that those will continue to be restricted to a certain degree, whether that is for 100% local ownership or still majority local ownership. The expectation is that those, if not all of those, then many of those and perhaps more will fall within the strategic sectors and so not be open to 100% foreign ownership. Similarly, under the FDI law, if you wanted to invest up to 100% in a positive list sector, there were various requirements that you had to meet. And really it was to help develop business and the infrastructure of the UAE. And so you had to invest capital, you had to use new technologies, you had to commit to research and development obligations, and you had to engage UAE nationals too. So it's not so easy as just coming in, or at least under the previous law, and saying, okay, great, I want to be on a positive list, give me 100% ownership. You had a lot of obligations you had to commit to. Next slide, please. Next slide, please. Okay. Don't know if we're having a technical problem. I cannot see the next slide. Mark, can you see the next slide? Or is it just me?
Okay. Sorry, William, I'll just check.
No, we've frozen, I think.
Yeah, just give me a second. Yeah, I think Sandhya is just having a technical difficulty. Just give me a second.
Okay, sure, no problem. Well, I'll go ahead and talk about what's on the next slide, and then we can.
By the time,
so as I mentioned, okay. So as I mentioned, the amendments don't just talk about foreign ownership, even though that's sort of been not the only thing, but the main thing that's been talked about in the press. In fact, as I said, there are over 50 changes to the company's law. Some of those changes, in fact, a lot of those changes deal with corporate governance reform. Some of them may seem fairly mundane, but in fact, they're going to have a significant effect on how companies are run in the Emirates. And similarly, we still don't know all the details, but those should be forthcoming early next year. As an example, one of those requirements is how you call a General Assembly for companies, and that's for both limited liability companies and joint stock companies. Another important reform is the fact that there will be an opening of the number of board seats that were previously reserved to Emiratis. For public companies, they will be allowed to float up to 70% of their share capital. The previous limitation was 30% on UAE stock markets. That's a big change. The memorandum of association of a company needs to include a dispute resolution provision between the company and its managers or directors or with the shareholders. And now all companies are going to have to comply with this by January 2nd of 2022, so 1 year after all of the amendments come into effect. So it'll be very important for every company to take a look at how they're currently run and what needs to change. And so with that, I'm going to hand it over to Mark, who's going to talk about some of the practical details of what this all means.
Mark, I'll just inform you that the slides are back.
All right, thank you very much. Let's go to next slide. So, practicalities. As I say, that there has been, as Bill has mentioned, a lot of discussion. A lot of the discussion and the excitement, I guess, that I've seen or been exposed to from companies in light of the announcement relates to this changing of the foreign ownership rules. As mentioned earlier on, I do a lot of work within the creative industries, technology, IP related, brand franchising, etc. So over the years that I've been operating in the Middle East, there has been a considerable reluctance, particularly with foreign investors, when the issue arises of whether you look at an onshore setup. Obviously, we have a raft of free zones that have arrived across the region, and obviously we have a large number of those in the UAE alone. One of the drivers for those, I'll come on to some of the other reasons, I guess, that free zones exist and how they may be looking to adapt their proposition a little later. But one of the driving factors that free zones tended to present, and certainly in the early days when we had, you know, Dubai Internet City and so on coming on track, it was very much driven by the opportunity for foreign ownership within the UAE. It did, however, does still have certain restrictions attaching to that. Although, you know, Bill will touch on that a little later as well. So the reason I think that it's prompted so much excitement is that it does create an additional option. I mean, that option can impact on a number of different levels, I suppose. But if we look first of all at new investors and company setups, inevitably, whenever anybody comes to me to talk about the options for entering into the market in this part of the world and in the UAE, we have to go through the broad range of possible options at a company setup so that we can tailor it to whatever the business objectives and activities of the client may be. Now, this, I think, adds an extra dimension. So one of the biggest areas we always have is how to cater to contractual or legal aspects of having a 51% shareholder in the business here. So if that were to change and there truly were an option available, I think there will be a very broad interest from new investors looking to set up in region, who will look to go potentially for the 100% onshore setup, which theoretically has broader opportunities attaching to it. And I think this is going to be relevant for many sectors. It's been one of the hot topics, I would say, for, well, I mean, you know, the last 20 plus years in terms of my work in the Middle East. Industry sectors like the creative industries, production activities, marketing and advertising related work, anybody that is in the event management field, although there are extra difficulties there, I guess, in terms of limited liability accessibility. So I think it's going to generate, it already has generated quite a lot of interest for that reason. It does create another option that previously has fundamentally not existed. It takes away the apparent specter of non-100% ownership and control of a business. Now, we also have existing onshore companies. So Bill had said earlier on, it isn't quite as easy as saying, okay, the law becomes into effect at the end of Q1 2021. So okay, let's get on with it. It's going to be a lot to do with existing, as well as the additional restrictions that will come out in cabinet resolution and on a specific Emirates DED basis. We also have to look at the contractual aspects and commercial aspects that already exist within your context as an existing onshore entity. So if you're looking to convert to a situation where you've got a 100% foreign ownership, dates and timing is crucial. You have to think about things like, when are payments due? When is your 51% local partner due to renew current arrangements? When will the very often annual fee or sometimes profit participation arise? Under the documentation that has been agreed with the 51% local shareholder, which varies very broadly from that there are all kinds of arrangements that people have attempted to put in place contractually despite the law to seek to cater to this 51% local ownership and control aspect. So we have to look at the contracts. Are there any restrictions, timing difficulties, implications relating to anything that has been attached to what is going to be necessary, namely a share transfer? So the 51% local shareholder is going to have to transfer that 51% to the foreign owner. So there's quite a lot to think about. It is all very practical stuff. When you look at other options as well, I know within, again, the creative industries and related industries that are based on SME involvement, a lot of them have looked to move towards the free zones. But again, if you're looking to shift from a free zone entity, which may give you currently 100% foreign ownership capability, but in the context of the free zone and its regulations, if you now want to consider the option of transferring onshore with a 100% foreign-owned company, again, timing is going to be important. Again, it's all to do with the detail of your particular situation. So under your arrangements with either your landlord or the free zone authority, what are your lease arrangements? Do you have any break clauses? Will there be any penalties or 3-month notice requirements, which is going to have a financial implication? The process is not, if you're in a free zone, it's not so much about conversion. So if you're an onshore entity, there will be a process in place for you to convert your currently 51% locally owned entity into a 100% entity. It's the same entity, it just will be a conversion process. With free zone entities that are looking to take the benefit of this now potential 100% onshore ownership, you are in effect closing a company, namely your free zone company, and setting up a new one. So there are very practical implications relating to all of those kind of issues. Next slide, please. So here's some summaries. I think some of the issues that we're touching on here, I think are practically very important. So you will see a little bit of mentioning similar issues over and over again, because I think this is actually the important from my point of view in trying to enable people to operate within their business sectors. It's all about the practicalities and nuts and bolts day to day of what they have to do. So we have to think about potentially exiting existing lease arrangements. So if you're in a free zone, as I say, the difference between exiting and close down of a free zone LLC with all of the implications that that might have, anybody who works within or exists currently within the free zone knows that depending on the free zone, there can be quite a lot of administration involved in changing, closing down various other aspects. Compared to the differences and the different process that you'll be facing if it's an onshore LLC and a conversion. It is key to deal with, as I say, the existing contracts and arrangements with the 51% local partners. Again, over the years, I've seen many different provisions here, some of which are attempting to do things that strictly speaking were not permitted in the law, but we would have to go through those. We would have to look at any enforceability issues that may arise in relation to any of the contracts that have been put in place. And we have a lot of so-called side arrangements relating to LLCs operating in the Middle East. So we would have to look at what the particular documents were in place and whether there were any conditions relating to the required share transfer from a 51% local owner to the foreign owner. Again, those key differences. So it very much does depend on what your particular circumstances are and what it is that you're looking to achieve. There are the fundamental differences between a shift to from an existing LLC onshore to a converted foreign-owned one versus a free zone closure and a new setup. So it's all the practical implications of that need to be thought through. Next slide, please. I mean, on some of the implications, I think the areas that Bill has mentioned are still uncertain and are super important in the context of any decision that any new investor, any existing LLC owners, or any FZ LLC free zone entity owners may be considering. So we still don't know certain key things. As Bill says, that they sit on two levels. There is the committee involvement, and no doubt I would expect another cabinet resolution that will come out to give broader explanation relating to that issue of what is a strategically important activity or business. And then secondly, it then will roll to the various Emirates and the departments of economic development within each Emirate to then deal with the ownership thresholds. So again, we're not completely certain as to whether or not there will be a free carte blanche relating to all sectors and 100% regardless of activity or sector. So these are still big questions that will have a commercial impact without doubt. The possibility, and this is what Bill again was referring to a little bit, the possibility relates to how close or different future provisions will be to the previous FDI position. We can only speculate at this stage. We don't know how the different Emirates will deal with the issue of percentages of permitted foreign ownership. There may even be differences Emirate to Emirate. We don't know if they will apply particular capital requirements for any grade of increased foreign ownership, perhaps related obviously to the different activities and depending on which trade activity category your business and operation falls into. For sure, there is a possibility of even more difference. I know we're very used to this in the UAE. I know we work with a number of layers of law and regulation, but that is a possibility here, in that from an Emirate to Emirate approach, there is without doubt the possibility that we will have some degree of inconsistency. That therefore means, and apologies, I know I keep saying this, but it does mean that we have to look at the specifics on a case-by-case basis. There is no getting away with it, I think, in the current context. Next slide, please. So the applications as well, we still don't have the full process as to how applications may be filed, submitted relating to conversion. Again, there is a difference between the conversion of an existing entity compared to the incorporation of a new entity under new ownership rules. The thing that we don't specifically know, and I know we keep repeating this, but it is important. All of the excitement that came out, and anybody that saw the initial press coverage, was all about the change to ownership. Now 100% is permitted. I think it is inevitable that that will occur in part, but we still don't know whether there will be any grading of ownership percentages. And secondly, we don't know the circumstances within which, at the end of the day, the Departments of Economic Development in each of the Emirates, we don't know the instances in which they will approve more than a 49% foreign ownership. We don't know the conditions that may be attached. Again, we can speculate based on some of the conditions and expectations that have been built into the previous FDI mechanisms, but we just have to wait and see. Next slide, please. A little bit of future proofing as well. So as I say, we have to consider what conditions may be attached to different trade activities. One of the questions that I've been asked a lot is it possible that there will be a differential treatment depending on your foreign ownership percentage relating to, for example, not only conditions that might be applied, fees that might be applied, and perhaps different tax brackets. So there hasn't been any official discussion of that yet. But again, looking forward, it is always possible. So I think that's one area to keep in mind as we see regulations or the cabinet resolution and the DED rules giving extra explanation about how the process is going to work. It is super important to review existing agreements, these side agreements that I mentioned, with the existing nominee shareholder, the 51% local participant. We have to look at termination. We have to look at any restrictions attaching to a transfer of shares. We have to consider whether there is any payment implication, because that all depends on how that has been dealt with in the corporate documents, including any side arrangements. I think another point, Bill was quite right. I mean, there have been a lot of changes. There are two reasons as to why every existing LLC will need to review its memorandum of association for two reasons. One is to cater to the broad range of changes that have been triggered by the 51 changes to the company law. Secondly is the adjustment position. So the new law does talk about regulating the position under the memorandum of association relating to any change in ownership structure. Fundamentally, what that means is that we have to amend memorandum of association. So again, we should be looking at that for existing entities. Another question people have asked quite frequently is how long have we got? When do these changes have to be brought into play? Bill has already talked to that. But on this adjustment position, the changing memorandum of association to comply with the new requirements, again, we don't quite know how that might work. I mean, the last time there was some kind of a raft of changes, there was an adjustment assumption in a resolution that was created in as an example from 2016, which was the most recent one. It did issue a provision to say that it was okay and you were in compliance to the extent that you had already complied at the point that the resolution was issued. So there is a possibility that there will be some flexibility issued in the future. So that is one that is worth watching for, I would say. There are quite a few other implications that I think are quite important at an economic and commercial level. And for that, I'll pass back to Bill.
Thank you, Mark. Next slide, please. So what does this all mean? And I guess what is the hope in terms of what this could do to help stimulate activity here? Presumably, this is going to help open up the market for various activities, including in particular M&A, private equity investment, joint ventures. It's been a challenge for many foreign companies, especially for big global corporations who are used to having control locally in the jurisdictions in which they operate, to come into the UAE and some of the other Gulf countries. I mean, one thing that'll be interesting to see is after this is rolled out, will the other Gulf countries that have foreign ownership restrictions, will they follow suit? You know, quite frankly, a lot of companies have either had to set up, you know, rather difficult structures that quite frankly require a lot of work from lawyers and accountants and everything else, and they get a bit cumbersome. And there are questions about their enforceability and all sorts of issues related to that. Or they just decide, you know what, we're not going to invest there. We only are in a place, you know, we want to control our brand, we want to control our operations, and if we can't have majority ownership, then that's not for us. So hopefully these changes will relax that and encourage more foreign investment. So in that regard, if you are a foreign corporation or representing a foreign corporation, you know, you should take a look now before the changes actually come into effect and sort of see what those commercial arrangements are, and see whether, assuming you are not stuck in a strategic sector, but are in a sector that is open to up to 100% foreign ownership, think about what you want to change in those arrangements, and whether that's on the equity ownership itself, share transfers, exit provisions, etc. On the flip side of this, not only will it hopefully make foreign investment here easier, it should also make it easier for UAE businesses to list abroad, because the local ownership requirements have made that a challenge as well. Next slide, please. So we're going to talk quickly, about the free zones. And we'll try to go through this fairly quickly because I know there are a lot of questions. But one of the big questions is, okay, so we've got this new law now. Why do we need free zones anymore? And aren't they all going to just disappear? Well, I don't think they're all going to just disappear. I do think many of them are going to come under some significant pressure. Some of them will be fine, although I think even they will come under pressure. You know, great example is the financial free zones. You know, they offer an infrastructure, they offer a corporate entities that are very flexible, that are based on common law principles. They have their own court systems. They have a very sophisticated financial regulator. They're not going away. Now, I think a question you could ask is, okay, they may not be going away, but if a company can set up in DIFC or ADGM, but maybe they don't need to, and the rents there are at one level, and in a place like Al Quoz, they're a fraction of that, they might reconsider, or perhaps they might try to set up some, you know, have a dual structure of some sort where they have a lot of support in a cheaper area. So I think there could be some pressure on rents in some of these free zones. But I think in general, what it's going to do is it's going to just create some healthy competition and make all the free zones be a little bit more nimble and try to think what can they do better to continue to attract companies. But I do think the result of this is you are going to see some free zones that just either disappear or consolidated or you know, merged into other free zones. all the free zones are really going to have to think very carefully. I'm sure they are all, we're a bit, for those that didn't already know about it, we're a bit shocked by this and are already very carefully looking at what they need to do. Mark?
Next slide, please. So that, for sure, I think is a key point. I mean, we do quite a lot of work in the free zones for a variety of reasons across numerous sectors, but including the SME sector generally, new market entrants, the creative industries, production, events, marketing and advertising. There are a whole range of reasons as to why we have seen an increase in the number of free zones over the years, particularly over the last couple of decades in the UAE, 20 years or thereabouts. Again, it is a specific assessment of what the requirements of a business are and whether or not a free zone is going to meet those requirements. So Bill is correct. I think some of the propositions are and will remain very clear for several of our free zones. But one of the primary drivers in my experience over the years has been this deterrent that foreign owners, new entrants into the market have had a deep reticence about this 51% requirement for foreign ownership, or requirement for 51% foreign ownership. The 2 points that Bill talked about, really, proposition and cost, are still, I think, going to be a deep implication. Next slide, please. So the specifics of the situation are always going to demand that you do look very carefully as to what the position is. I think Bill is absolutely correct. There is going to be some shift. There is going to be some degree of consolidation. We may even lose some free zones. I think it is very much incumbent upon the free zones now to look very careful at their business model, their proposition, the specific benefits in the absence potentially of an exclusivity in relation to the 100% foreign ownership. Free zones are going to have to look very carefully at what it is that they are offering prospective investors wishing to set up. But similarly, when your investor is looking at the options and they are now considering the onshore possibility, we still have to think about the practicalities. The reality is, I think that there will still be certain changes. Lease costs, office space, there are quite possibly going to be conditions that are going to create, for different sectors, higher barriers to operate in an onshore 100% foreign-owned LLC context. This is why we keep referring to the likely cabinet resolution, which is going to set out licensing controls and to identify what strategic impact means, but also the regulations that are going to come through at an economic department level, emirate by emirate. From an SME point of view, it is possible that anybody looking to come into, there have been some questions on this as well, anybody who's looking to come into the area as a new market entrant, they may still decide at the end of the day that one or other of the free zones may be a more sensible start to seeking to set up in an onshore context. So all of that is on the specifics. Next slide, please. Very quickly, we have already seen a context where free zones and onshore were beginning to live together. So I think, if anything, despite what we're saying about uncertainty on future conditions and aspects that the local emirates may put in place, there has been a blurring to a degree, and it's been very important for certain sectors, retail and others. So I think, again, that's one of the specific areas that it is necessary for us to consider. So free zones aren't going away, but it very much, I think, is an issue, as we say, of the free zone authorities themselves looking at their proposition, their business model, they may have to change some aspect of it. It would have to be community driven. It would have to be providing some degree of potential cohesion in an industry context, and so on and so forth. There's practical issues to consider. And from the investor, new market entrant point of view, we are still going to have, one of the things about the Gulf is that there are a lot of options. There are still going to be. The question is making sure that we pick the right one. Over to Bill, and next slide.
Thank you, Mark. So, as you've seen, I mean, we have more questions than we have answers at this point. We're really just at sort of the beginning of this process of opening up to foreign ownership. But I think the general theme is that, while there are going to be changes, not everything is going to change, and what we've had is not going to completely go away. It's all going to depend on the practicalities and the direction we get in terms of further legislation. So I know you all have a lot of questions too, and we want to get to those. So Mark, I don't know if you want to have any concluding remarks before we get to the questions. I know there's one more slide. Maybe go to the next slide.
Next slide,
please.
Thank you. So, yes, I mean, following on very quickly. So free zones are still going to exist. It's all about the proposition. Does it make sense for you as a new investment, somebody setting up? We have to future-proof. We have to keep an eye on economic elements shifting. We've talked about tax brackets. We've talked about conditions and capital requirements. Within the previous rules, we had seen issues relating to conditions relating to the employment of UAE nationals. All of these have practical implications. And the very last point, every LLC should be reviewing their memorandum of association. There is an obligation for two reasons, as I mentioned earlier, to bring them up to date. So I know it's never a popular thing for companies to do, to review their corporate documentation. It is a requirement. I'll probably stop on conclusions there and pass over now and give a little opportunity for some questions.
Thank you, William and Mark, for sharing your insight with us this morning. One of the first questions that we had received was on the free zone companies, but now that you have, spent some time on it, let's go. William, the first question to you. Could we anticipate legal resistance from UAE national sponsors when shifting from 51% to 100% foreign ownership?
I think there'll be resistance, whether it's legal resistance, that might be, it depends what you mean by that. I can't see them, trying to go to court on this, because the law is what the law is. And if the law is in favor of a change, I think it will be difficult for them to put up a challenge to that. I think there's going to be a lot of discussion. I think there's going to be a lot of commercial discussion. And let's face it. I mean, we have many arrangements in this country where you really have a nominee who is just there to hold the shares, and that's pretty much it. There are a lot of other arrangements where you really need your local shareholder. I mean, before I came to the Emirates, I practiced in other jurisdictions abroad, and in certain places, you need someone who understands the local landscape, who knows the language, who knows the culture, who knows the business environment. And so I think even for those who may come in and have 100% foreign ownership, they're still going to need their local partner. So, as Mark said, it depends on the situation, and each situation is going to be different. But everyone's going to have to shift, and the local sponsors, some of them are going to have to shift as well, and also think about what their value proposition is, and what they can do to thrive.
Thank you, William.
I guess if there is going to be just one quick point, if there is going to be any challenge or friction in the area, I think it will be around the specifics of the situation, which means delving into the contractual arrangements that currently are already in place, not only the MOA, but also any additional side arrangements that have been entered into. And from company to company, they will vary massively.
Okay, thank you, Mark. Mark, will there be a minimum capital requirement for LLCs, and which sectors are excluded?
Sorry to keep repeating it, but currently we don't know. It is possible. The kind of conditions that could be applied may include different capital requirements. It may include some of the kind of requirements in terms of R&D and technologies and so on that we had seen under the FDI approach. In terms of sector, so specific trading activities variation, again, I think that is very possible. The reality at the moment is that we don't know until it comes out. We're just guessing.
Okay, thank you, Mark. And a bit more specific, will existing companies be permitted to remove its Emirati shareholder? And will the changes apply to an architectural consultancy firm?
So, I mean, first of all, yes. The answer to the first question is yes. Assuming it's not in the strategic sector, in theory, yes, you should be able to remove the Emirati shareholder. And that goes back to the question we just talked about the practicalities of that, whether you really want to, and whether the local shareholder might dig his heels in and try whatever he can to make things difficult. In terms of an architectural consulting firm, I'm not sure that would fall within the scope of the commercial companies law. And so, as we've been saying all along, it's a question of taking it case by case. So I think we'll just have to see on that. Mark, I don't know if you have any thoughts on that.
Yeah, I mean, it is a part of the process. It always has been. There's no change now. So this case by case analysis that we keep talking about, I mean, it literally is what we have done. What I've done for the last 20 years here. It is a part of the process. There are other issues. So sometimes your trade activities fall into a context where it may not be possible to be given an LLC status, and therefore we've had to look at other areas. I mean, this has happened in various aspects of the creative industries of areas where any kind of creative development might be involved. So there has been a move towards seeking a proper trade activity, but under a sole proprietorship, for example, a different kind of license without limited liability, versus trying to maneuver your trade activities under a limited liability trade license. So honestly, that is still a part of the process. It is all about trying to see what the business objectives are, and then you look at how best to achieve that in light of the many options that are available within the UAE.
Okay, thanks. Now, I think both of you can weigh in on this question. The pressure of Emiratization and future changes in law may impact expat business owners in such 100% investments. What is your view?
Possibly. I mean, again, because this is partly an issue of waiting to see what the conditions are going to be. We certainly have seen this aspect before. It will be a practical implication depending on your type of activity, depending on your business and your objectives. And it also depends on how extensive the conditions will be and which trade activities any requirement for the employment of UAE nationals might apply to. So possible, we don't quite know. If it is, then you have to look at it. It's down to the practicalities and of the situation. Could it impact expat business owners? Absolutely. If it would require a shift on a number of levels for many businesses looking to operate as a limited liability company in the region, and certainly for SMEs.
Yeah, and I think I would just add that there's no such thing as a free lunch, as they say, right? And so this new opening up, this liberalization, it's not going to come without conditions. If you look at some of the other countries in the Gulf, you look at Saudi, The Saudiization requirements are different just because there's a much bigger local population than there are expats compared to the Emirates. But you look at some of the capital requirements they have for some of their companies. I mean, the whole idea here, this is not, I mean, this states the obvious, of course. The UAE is not doing this to make the world a better place for all foreigners. I mean, they're doing this to make the UAE a better place, right? And so they're hoping that with this investment will come, whatever it is that's going to help make the Emirates a better place, and that is the capital investment. That is getting more, getting better experience for the local population. That is R&D and new technology. So yes, I think there will be more pressures. There's going to be pressure on everyone. I mean, I think one of the themes we keep talking about is the free zones are going to have to adjust. We talked about the fact that there may be different requirements between each emirate in how this rolls out. There's going to be competition among the emirates, which can show themselves to be more flexible, more attractive. This is all about creating more competition, and more competition is healthy. It creates better markets, and hopefully that will make life here better for everyone.
Thank you. I think one of the questions, you probably already answered it, but will the requirements of 100% foreign ownership be same in all the Emirates?
Yeah, I mean,
possibly.
Yeah, I would think not. I mean, and I think that is going to go down to this question of competition. Some Emirates, let's face it, Abu Dhabi and Dubai, they already attract enough foreign business by themselves. They're probably going to be under less pressure to be innovative than some of the other Emirates, and so I would expect to see some of the smaller Emirates maybe trying to be a bit more creative in terms of their offering.
Okay, great. We do have some more questions. I know that the delegates are staying behind, so if we can take another few minutes, if that's okay with you.
Sure.
Okay. Yeah. So, William, what happens to the existing companies with the 5949 structures?
Well, I mean, first of all, this is not an obligation to change. And so there are some companies that may just decide, it's too much trouble. We're perfectly happy with our local sponsor. They do a good job. They help us out. Let's just leave things as it is. If it ain't broke, don't fix it. But I suspect that everyone is going to, at a minimum, be, reassessing and considering their options.
And what about the previous measures to allow full foreign ownership in 120T activities? Did it have a substantial impact on FDI, Mark?
I think it opened the doorway, I think, to what we are seeing now with the possible implications of the article change in the new law. I think is possibly an extension of the pattern that commenced then. Obviously, we've been talking about this removal of 100% of a 51% local ownership context in all the 25 years I've been operating in the Middle East. The first real step came with the FDI provisions. However, Bill has talked about the fact that it was the level of exemption was the other way around to the way it is now. So it was on a case by case, and were there a lot of allowances? There weren't. There was no, as Bill says, there was no fundamental and massive shift of landscape or in the landscape. The potential of the new change is that we may actually see a considerable landscape shift. So I think it's mostly currently about looking to the future and seeing how this implication changes with what is a fundamental potential shift of approach.
Yeah, and I think I would add to that. I think one of the questions that came in previously was something along the lines of, is this the beginning or the end of the foreign ownership changes? And I think it's sort of the middle. I think this is a process. Even though depending on the details of the clarifications that come out, we still don't know what's going to happen. But even if it is, going to open up the playing field quite a bit, it's going to be a process that takes time. And I think both in terms of rolling out this law and the practicalities that follow from it, but also in terms of other steps, other legislative changes in the future. This is all going to unroll over a period of probably several years, I would think.
Thank you. Mark, there's a question for you. Can you please clarify if there is any impact on the companies that are importing their own brands into the country to be sold through wholesalers, commercial agents? Can such companies operate on 100% foreign ownership?
Bill's going to laugh. I will give my usual answer. It depends. So obviously, when the review of what a brand coming into market is seeking to achieve can lead you to vastly different conclusions, I guess. It is still down to that issue of what is it they're trying to achieve. Do you need third parties, local participants to be involved in that? And remember, what we are talking about here in any case is effectively the LLC ownership rules. We still have other rules that we still need to operate within. So we still have rules and regulations relating to regulation of competition, relating to the appointment of a commercial agency and under regular or relevant rules that differ slightly from quite a bit from country to country. So that impacts on agency, distributor, and even franchising and licensing arrangements in certain contexts. So there are options available, is what I would say, but it is very much down to the specifics of what you are trying to achieve with your brand, and what the practical implications from people to sales to import and export to where you warehouse to what the nature of your brand model is. Is it face to face? Is it storage and distribution? All of those have an impact on a proper decision for how you enter market.
Thank you, Mark. William, there is a question here about how these new rules impact regulated financial service firms.
That's a good question, because I think in part it's going to depend on what the strategic sectors are. And as we saw with the previous FDI law, the banking sector, it was a protected sector, and I expect that will be the same here. And again, that's the raison d'etre for the financial free zones. That's where you have all the foreign banks set up. So that'll be interesting to see. I don't know. It's a very good question, but not sure. We'll have to see about that. I mean, I would think that there's going to be some. Well, I mean, the financial free zones themselves will probably lobby to keep things status quo in that sense, because if all of a sudden the financial system opens up, they may start to struggle. Although, again, I still think because of their infrastructure and the corporate setup of the entities, the courts, and all that, they'll still have many advantages. But that's a good question. I'm not sure at this point. We'll have to see.
Okay, we'll just take two more questions. Is it mandatory for all existing companies, partnerships, LLCs, establishments, etc., to amend their AOAs to meet the new regulations in the decree? Is there any time period allowed by the authorities to meet this new requirement?
Yeah, so I mean, we talked about that, and I think it's even here on the slide that's still up. So for those companies that do have to amend their articles, they'll have a little over a year. So 1 year from the day when it comes into force.
Okay.
Penalties will apply if you don't deal with the MOA adjustment that is required. as I was mentioning, that there may be a new resolution may come out giving some flexibility on that, as has happened previously. But the bottom line is that every company 100% should be reviewing their MOA and related corporate documents to see A, what changes do they need to make, and B, obviously, any changes that might be required in light of a change of ownership. So yes, you should at least be assessing it for sure.
Mm-hmm.
And I think I would add to that putting aside this law and the requirement to do it, it's good practice. I mean, that's what a well-run company should be doing anyway. They should, the problem that a lot of companies run into with their policies, whether that's their internal governance or their compliance policies, is they spend the time to draft the relevant document, and then it sits on a shelf, or these days, I guess, a virtual shelf, and collects virtual dust in that sense. And that's not the way it should be. These should be acting, living documents that change as the needs of the organization changes, and it's very important, because what happens is the organization changes, the documents don't, and then you have an inconsistency, and that can lead to problems. So yes, our lawyers like us happy to see a provision that says, yes, you must change your articles within 1 year? Of course we are. That's great for us. But the fact of the matter is that as a matter of good corporate housekeeping, you really should be regularly reviewing your articles and really all the other policies that govern your organization.
I'm going to throw just one quick point. I think the question you had referred to, for example, not only limited liability companies on shore, but also partnerships, free zone establishments, etc. I mean, different rules apply. So the commercial companies law and the changes that are being implemented, the 51 changes, apply to the specific forms of entity that are referred to in the amendments. Free zones operate under different rules and regulations set out normally in a variety of ways, but included by the regulatory authority for the free zone. The same rule that or the same best practice that Bill has just mentioned applies to all of that, whether you are running a sole proprietorship or whether you are running a free zone company. Your corporate documents should reflect what it is that practically you are doing, and they should support and embody a business's practices and protocols. Otherwise, when somebody then pulls it off the virtual shelf and gives it a virtual blow away of the dust, then when we look at it, there are problems.
Yeah.
And unfortunately, we see that too many times. I could tell you of a dozen on my desk at the moment that fall into the category of not having kept consistency between business requirements, practices, and protocols compared to what's actually written in the document they might have done 7 years ago and have not thought about since.
And I'll just add to that for a second, and we're getting a little bit away from the topic of foreign ownership, but I think it's important. Yes. Probably one of the biggest problems that I have seen in my practice is exactly this, is that because people don't have the internal procedures in place, or because, quite honestly, whoever's supposed to be doing it isn't doing what they're supposed to, they're lazy or forgetful or whatever, or quite honestly, sometimes because people don't want to spend the money and the time to engage lawyers or other advisors to go over this stuff, and they don't review their policies. That causes huge problems, and the time and expense that you will have to expend to do that exercise is minuscule compared to the exercise you'll have to go through when a big problem arises. Yes. And I've seen it. I've seen it in compliance contexts where you spend, I don't know, a few hours a year, a few $1,000s to go through and update your documents. And if you don't, and then you have fallen afoul of a new regulation, then you're talking thousands of hours and tens of thousands, if not hundreds of thousands of dollars, dealing with regulatory authorities, worrying about sanctions and being, paying huge fines, all sorts of things. I mean, massive problems have arisen because people don't take the time to review their policies, make sure they're in line with current practice. So I can't emphasize that enough.
That's great advice. Thank you, William. One last question. It's a bit of a long one, so I'll read it. With the amendment to Article 10 of the Companies Law on the assumption that the retail sector will not be a strategic important sector, do you foresee an amendment to the certain provision in the UAE Commercial Agencies Law, particularly the extensive protected rights of a registered agent in the UAE who is past practice typically have been local registered agents? I hope you followed that. If you want me to read that again, I can.
Wow, no. I mean, I'll just make a couple of comments initially. Look, so retail sector. So a lot of my business is in the face-to-face experience sectors, which have been obviously massively impacted recently. I think there are varying views about whether the retail sector will continue to have a reduced strategic importance. I think we have to see, how things, shape up during 2021. For sure, it has been impacted in terms of obviously the cessation and or reduction of activities within retail sector. So I think from my point of view, I think there's still legs in the retail sector yet from a strategic importance point of view. And then the other bit that you're mentioning here is the commercial agency regulations. Look, one of the things about, look, it's the same in any jurisdiction, but for sure it's the same, it is the position in the Gulf. There are a number of either parallel or sometimes, honestly, slightly conflicting provisions that you have to deal with. Do I think this is directly going to lead to a removal of the commercial agency law? I'm not sure that I would say that. I think on the commercial agency front, remembering the broad spectrum of things that it can impact on, agency, distribution, franchising, licensing of certain sorts, we have to be very alive on a literally week-to-week basis of how those provisions may impact on what you are trying to do in terms of homegrown brands coming in, service-led brands. A lot of it has to do with important issues, including brand governance issues. So the way that regulation and economics are going to change leads directly into the issue of brand reputational strategic control. So I don't think we're going to see the commercial agency rules disappear tomorrow. I think there will continue from Gulf country to Gulf country be changes, as has always been the case. And the issue from a retail or any brand business operating within the region is you have to be alive. You really have to be alive to that at a regulatory level on a day-to-day basis. Sorry, that was a long answer to a long question.
Thank you, Mark. William, would you like to add anything, or shall we get on to the conclusions?
No, I think that's right. I mean, I think that it's a great question, and it probably is something that will be looked at to what extent it will change at all. Yeah, very tough to say, but very interesting question. Very interesting question.
Okay, great. Thank you. Thank you, William and Mark, for offering your practical insight on this crucial topic. I'd like to add that if the delegates have any more questions, please do reach out to them, or you can send in your queries, and we would be happy to forward it to both William and Mark. Our sincere thanks to the firm, Charles Russell Speechlys, for leading the discussion. Hoda and Emma at the firm, thank you for your help as always for organizing this session. We would also like to thank our legal research partner, LexisNexis, for their support, and also to my colleagues at Niche Publishers, and especially to Sandhya Divakaran, who is the co-organizer of this session, for your support this morning. A recording of this webinar will be available on the Oath Magazine's website. Thank you for joining us this morning. This will be our last webinar for the year 2020. We look forward to more sessions next year, although we are hoping that we can get back to hosting physical events. We've all been through unprecedented challenges this year. However, it's also been a year of great learning, perseverance, and transformation. So I wish you all good health and a wonderful new year. God bless. Thank you, William and Mark. Thank you.
Thank
Thanks,
you.
everyone. Thank you.
Keep safe, everyone.
Thank you.